Cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky, we're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people.
That's right.
Power back to the people.
Hey, 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 hey. Me? Good morning, good morning. Get your skates ready, Ann. I'm feeling it. It's Wednesday, folks. Bam, 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 bam. Telling you. Welcome back to Day 9 coverage of Coyote Springs versus Nevada. You're tuning into W4Nevada Live. I'm Matthew Winterhawk, and I have no idea what I'm doing. No, we are we're continuing the day coverage now, Day 9. Amelia Cargill will be getting back on that stand, I'm sure of it. And we're just going to resume our coverage as usual. Hopefully they won't redact and try to go all confidential like they did 3 times yesterday. Hutchison made it clear that he didn't want estuary mentioned, and he didn't want the Latter-day Saints water rights discussed and or the profitability thereof. So that was wild. That was a quick Lemony Snicket's turn of events. Here we go. Looks like we're getting a little bit of the feed already. Fantastic. Timing going perfect. Let me get my note-taking skills abilities ready, and we will get it going. Hope you're excited as I am. Day 9 trial coverage, week 3, by the way. How that works, I don't know, but we are on week 3, and this is day 9. Look forward to the morning recess update that I will provide, the afternoon lunch recess that I will provide, excuse me, the lunch recess, and then the afternoon recess, as well as the day wrap. So look forward to those updates today if you're unable to tune in. And the coverage itself is streamed, live recorded, I believe 10 different platforms. You've got Twitch, YouTube, TikTok, Kick, Facebook, Rumble, Instagram, name it. We're out there. We're live, folks. We're making sure that the world knows, and more importantly, Nevadans know what is going on with this case. So once again, thank you to Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Nye, Mineral, Pershing, Story, Washoe, and White Pine. Not just 2 in a sports book, right? We love you, Clark and Washoe. Not as much as you love yourself, but we do love you. So we will continue that coverage today. Let's see what we're doing while we wait. Shouldn't be long. We've got 5 minutes here. Let me throw on a track. Give you a little bit of music while we watch this screen. And as that comes on, I will silence the music itself. That's what we will do. 5 minutes. 5 minutes to fill it with some music. Today is it Wednesday? August 12th. Happy birthday to my son. 11 years old today. Isn't that wild? We've been celebrating all week, by the way. He will be getting a second birthday cake today. And who knows what shenanigans will unfold as the day goes on. But I look forward to it. It's a fun time. As a parent, I'm sure some of you out there are. It's a great time in life. What do we got now? 4 minutes? Oh man, I don't know if I got a 4-minute song. Talking away the airwaves here. This is not my intention, folks. It's just that things are taking extremely long to get going here. Am I not on the right profile? This is the right profile for sure. Library. Unfortunately, when you do music on live streams, you have to make sure, and that's the cool thing about AI, which is why people don't understand. I'm not anti-AI. I make music all the time with AI. It's fun. Enjoy this one about having tough skin in the world of today. While we wait for this court case to pick back up here, and we'll take our notes and get our updates out. You better have tough skin.
Better have tough skin.
They call me alligator.
They call me alligator. Started out as friends.
Hey.
Then became your hater. I'm moving through the swamp, yeah. I'm cold-blooded now. You thought you knew the game, but I'm showing you how. Yeah. Tough skin, that's the state I'm living in. Tough skin, let the heavy bass begin. Tough skin, pressure made me who I've been. Tough skin, watch me do it all again. I came up in the mud, had to grind for the shine. Turned the pain into fuel, kept the hunger in my mind. Turned the doubt into drive, now I'm sharpening my craft. Every scar is a lesson, every setback made me laugh. I learned real quick who was solid, who was counterfeit. Some will shake your hand today, tomorrow they abandon ship. Pressure made me dangerous, pain became a language. Now I smile through the fire like I never felt the anguish. They threw dirt on my name, I grew roots instead. Every rumor fed the soil, now I'm living in their head. I don't bark for attention, I don't chase the crowd. Silent water run deep, but the thunder talk loud. Better have tough skin, they call me alligator. Started out as friends, then became your hater. I'm moving through the swamp, yeah. I'm cold-blooded now. You thought you knew the game, but I'm showing you how. Oh, tough skin, that's the state I'm living in. Tough skin, let the heavy bass begin. Tough skin, pressure made me who I've been. Tough skin, watch me do it all again. I was molded by the storm, every wave made me strong. Turned the pressure into gold, now I'm living in the song. You can test me if you want, but I'm built for the strain. I'm the proof that the struggle put some steel in my veins. Every scar got a story, every bruise got a price. Had to lose a couple people just to see who stayed for life. They was praying I fold, I was learning how to bend. Funny how they switch sides, now they calling me again. I don't carry all that hate, I just carry what I learned. Every bridge that they burned became another place I turned. Hard cold like the swamp, mind sharp like a blade. You can copy every move, but you can't copy how I'm made. Better have tough skin, they call me alligator. Started
much as I would love to continue that, looks like the court is about to resume. We'll be reconvening here. Thank you so much for tuning in, by the way. And that song, if you're interested, reach out to me. I'll send it to you. It's called Tough Skin. It's a great song. They call me Alligator, by the way. Started out as friends, then became your hater. It's a great song. Let me put on, I want to watch. Where's my captions, fool? Like how he's talking, but there's nothing really truly going on yet. Oh, I didn't hit go live. Poor Instagram. They missed out on all that. Ready, set, resume. I'm going to silent myself here, guys. Good morning.
All right. The Judicial District Court 2013 is now in session. Now we'll mark our deadlines on next.
Good morning, please be seated.
They will discuss this here. Okay. I don't think it'll be
Reconvening for non-jury trial in Coyote Springs Investment LLC versus State of Nevada. Please state appearances of counsel.
Good morning, Your Honor. Mark Hutchison.
Party representatives who are present today.
I'm sorry, Your Honor. Good morning, Your Honor. Mark Hutchison and Todd Kennedy on behalf of the Coyote Springs Investment LLC plaintiffs and related entities. And with us is the general counsel of those plaintiff entities, Ms. Amelia Cargill, who is once again on the witness stand today.
Good morning, Jeffrey Sylvester and Matthew Nealand of Sylvester and Plaintiffs on behalf of the state of Nevada.
Yes, Ms. Carter has retaken the stand. You realize that you're still under oath.
Yes, I do.
All right.
A couple of housekeeping matters. There are a couple of documents that we referenced yesterday and failed to admit. And Brendan, would you please bring up state's proposed exhibit 3770? So the witness and counsel can refresh their recollections of the document. You recognize?
Well,
Go ahead.
I don't object to this.
Okay. Then we would offer 3770.
3770.
Yes, Your Honor.
All right. Being no objection, as I understand it, right?
Stipulate.
It's admitted.
State's proposed exhibit 3741, please.
Next page, please. Yeah, no objection to this either, Your Honor.
And the number is 37.
3741 and 3740, please, Brendan.
No objection, Your Honor.
3740. Admitted.
Thank you, Your Honor. Miss Brendan, would you bring up, I believe, states admitted exhibit 3366? And we spoke about this, and I think we've actually finished our discussion, but just before we move to the next one to orient you in time, we're looking at applications for extension of time to indicate how much was expended and how much was anticipated to be expended on a go-forward basis. And you recall looking at this particular document yesterday?
Yes, I believe we did look at that.
Okay. And can you confirm that's in minimum? It is. Okay, thank you. Can I have state's proposed exhibit 3342 auto?
No, I think there were 38.
Yeah, this is I believe, a stipulated admitted document. And can you, first, Brendan, can you increase the size of that, please, so we can all read it? There you go. Miss Cargill, you recognize this document?
It's a proof of completion of work for permit 70430.
Okay.
And it was filed August 30th, 2005 with the state engineer's office.
And can we scroll down to the bottom to see the signature page, please? That's signed by Carl Sabley.
Yes, it is.
And what was Mr. Sabley's role at that time? Was he still acting as counsel for CSI?
In August of 2005, Mr. Sabley, I think, was a pretty new employee of Wingfield Nevada Group at that time. He started in, I believe, 2005, but I could have the year wrong, but it was right around that time.
And just to orient the court,
And he was general counsel. I apologize. He was general counsel.
he signed this on behalf of Wingfield, or I should say, as general counsel for Wingfield at the time.
Mr. Sabley, I would say, is general counsel for any of the entities.
And the affiliates as well.
Yes,
Okay.
so this would have been filed by, I believe it was filed by Coyote Springs Investment. We'd have to go back to the top of the form.
Go to the top of the form, Brendan.
Indeed, Coyote Spring Investments, general counsel would be his role.
And just to, as we discussed yesterday, just to orient the court again to what we're talking about, we had the base permit at 46777, right?
Yes,
And then it was split off to 70429 and 70430.
correct.
And what is the effect? In other words, do these essentially replace or substitute 46777? If you know?
I'm not sure of how what the state engineer, if how that really works. I know the word that the state engineer uses is abrogated. And that if you look on the state engineer's website, just like title to a home, all of those documents are referenced there.
And do 70430 and 70429 essentially capture all of the water that was part of 46777 before it's further divided? Your recollection.
Mr. Sylvester, I don't remember right now.
Brendan, can I have proposed, I'm sorry, I believe admitted trial exhibit 3342? I'm sorry.
Did you admit it?
Yeah, that's a stipulated admit, as I understand. 3435, Brendan. And see if you can expand that so Ms. Cargill and I can read it. This is a application for extension of time dated May 14th, 2009. And it indicates, can you advise the court with respect to how much money has been expended under or on the project under the permit the year preceding?
This states that in number 5, that the expenditure in the last year was $204,500 and that the total to date is $2 million.
So as of that date, the total at least expended on the project as defined in the application is $2 million for that portion of the base right that became 70430.
Yes, and as I think I said yesterday, I don't know if Carl was looking, what he was looking at when he pulled those numbers.
But this is what was represented to the state engineer with respect to the amount of money expended on the project in the year preceding and total to date. Is that accurate?
Related to this extension of time for 70430, yes.
Can we go down to the project, Brendan, a little bit, please? And you can read into the record what the what that item provides. Brendan, can you make it a little larger, please, if possible?
Yes, so number 7 says describe progress made during last year and explain in detail why it's the extension of time is being submitted. The well, and then Mr. Savely wrote, the well was taken out of service in 2008 to allow the removal of existing equipment and the installation of permanent equipment meeting municipal service standards. The existing equipment has been removed. Plans were submitted to the Coyote Springs Water Resources GID parenthetical LVVWD and parenthetical for approval because this well will be the initial well utilized by the GID to serve customers within Coyote Springs. The equipment has been purchased. Installation of the equipment will be scheduled in coordination with the construction of the water treatment facility.
Okay, and that's dated as of May of 2009.
May 11th, 2009.
What's the exhibit number?
3435.
It was 3435, and that document has been admitted, Your Honor, by stipulation.
This is not it.
And the offer-
We have no objection.
It's admitted.
I thought that was the numbers I rattled off in our.
Can you repeat the number, please?
3435. So as of at least 2009, that's the amount that CSI has advised the state engineer it has spent on that project as defined by Mr. Savely. Is that accurate?
I believe that's what I said, and that's what the application demonstrates.
State's proposed exhibit 3452. And expand the document at the top, please. This is an application related to permit number 70430, and it's filed on May 17th, 2010. And Brendan, if you could go to item 5 to talk about the expenditures on the project. And Ms. Cargo, how much does the document reflect was expended on the project in the preceding year?
In the preceding year, $200,000.
Okay, and then the total to date.
$2,200,000.
And if we can go to the description of the work, project, I should say.
Number 7 describes mass grading of well site was completed. Pads and electrical vaults were installed. Plans submitted to the Coyote Springs Water Resources GID parenthetical LVVWD and parenthetical have been revised several times and are nearing final approval by LVVWD as manager of the GID. Except for the bowl assembly parenthetical, which has been redesigned and parenthetical, the previously purchased equipment will be installed in the well. Installation of permanent equipment is scheduled to commence on or about July 2nd, 2010. It is currently anticipated that this well will return to production in February 2011. It is anticipated that it will take approximately 5 years after the well is returned to service to place the water to beneficial use. Construction of the GID's water treatment facility is approximately 90% complete. The chemical feed system still needs to be installed and punch list items completed before the treatment facility is ready for pre-operation testing.
Okay, and the water treatment plant, is that encompassed in the amount expended to date?
I don't know the answer to that, Mr. Sylvester. I don't know if Carl would have reached out to Pardee Homes and gotten those numbers from Pardee, because as you and I discussed yesterday or the day before, Pardee Homes of Nevada was constructing and paying for the construction of the groundwater treatment plant and the municipal equipment at well number 1, if my memory serves me correctly.
Under that JFI split, I think it was 87.5% that party was paying.
That is my recollection of the water treatment plant.
And so at least as of that date, the expenses incurred and paid by Pardee with respect to the water treatment plant were in fact paid by Pardee, to your knowledge?
Yes, they were. And as I described when we talked about the JFI, my understanding from what I was told at the time was that Pardee was paying for 100% of the expenses, and the CSI share would be handled in a true up at some point in the future.
Do you know in total how much Pardee paid for that construction of that water treatment plant before the anticipated true up?
I do not, Mr. Sylvester, not sitting right here.
To your knowledge, did CSI pay all or any portion of the construction of the water treatment plant as of the date of that application?
I don't know if there were any aspects of that facility or the land or preparing the land that Coyote Springs paid for, because the land hadn't been transferred to Pardee until a later point in time. CSI could have paid for some of the early costs. I don't know, sitting right here right now.
State offers proposed exhibit 3452.
No objection.
It's submitted. What's the date of that?
May 17th, 2010.
Brennan, can I have state's proposed exhibit 3514, please? And if you enlarge it so that Ms. Cargill and I can read it as well as the court, and Ms. Cargill, if you can identify that document, please.
This is an application for extension of time filed on May 8th, 2015 by Coyote Springs Investment related to permit 70430.
And so this is a continuation of the applications that we've been looking at as it relates to 70430.
Yes, it is.
Okay. And if we can go to line 5 and indicate what CSI advised the state engineer of the expenditures on the project under that permit as of that date for the preceding year.
So the information Mr. Savely has here, I can't recall right now how many years the prior extension was for. So what he has here is 3 different numbers. 76,400 represents what would have been spent in the prior year. Then he has a parenthetical that says 257,500. That represents what was spent in the last period since the last extension of time was done. If that was, I think, 5 years, that's the amount spent over the 5-year period by Coyote Springs Investment.
And how much then did CSI advise the state engineer it had spent in total to date on the 70430?
That Coyote Springs had spent was $2,457,500.
And if we can go to the project description, please, Brendan. And Ms. Cargill, if you could read into that.
Number 7, installation of the permanent municipal equipment was completed in November 2012, and the well was returned to service, and it remains in service. Construction of the Coyote Springs Water Resources GID, parenthetical LVVWD, and parenthetical water treatment facility has not yet been completed by Weyerhaeuser NR Company, parenthetical WNRC, and parenthetical successor and interest to Pardee Homes of Nevada, parenthetical PHN, and parenthetical. PHN had placed construction of this facility on a temporary hold, and WNRC continued with the temporary hold on construction pending resolution of the litigation between CSI and WNRC. Further, due to the significant parenthetical, and downward, end parenthetical, change in the real estate market, CSI's water use to date has been limited to dust control and irrigation purposes. Subsequent to issuance of certificate 17035, parenthetical, permit 70429, end parenthetical, the state engineer advised CSI that another certificate would not be issued until the water was used for additional municipal purposes.
And that says, again, what date did Mr. Savy sign that correspondence or that application, I should say?
The notary block says May 7th, 2015.
So that's the total amount spent on that permit is the amount in item number 6 as of May 1st, May 7th, 2015. And that number again is 2,457,500.
Yes, and item number 5.
That offer. Sorry.
No objection, Your Honor.
Admitted. 3514.
3514. May I have proposed exhibit 3734, please? And you could identify this document?
This document was filed with the state engineer's office on May 7th, 2020. And it is a application for extension of time under manner of use, municipal or quasi-municipal, permit number 70430, and it's submitted by Coyote Spring Investments.
And you can go down to the item number. I'm sorry, the last full paragraph, read that into the record, please. I'm sorry, Brent, stop at 10, please. And this is the amount spent on the project the preceding year and in the total to date, is that correct?
It includes, as the last one did, it includes the prior year, it includes the prior period, and it includes the total.
So for the record, if you read in the last year, which would include the prior period as well?
No, the last year was $13,114. The prior period was the $73,044. And the total to date is $2,530,544.
And then if we can go to the description of the project, please.
Item number 8. Subsequent to issuance of certificate 17035, parenthetical, permit 70429, and parenthetical, the state engineer advised CSI that another certificate would not be issued until water was used for additional municipal purposes other than dust control and irrigation. To date, Clark County has declined to approve a final map for residential development because the state engineer has declined to sign off on a sufficient water supply. Also, NDWR issued interim order number 1303, which placed a moratorium on the approval of final maps at Coyote Springs. A final order is expected sometime during 2020, and it is reasonably anticipated there may be additional delays as a result of the final order.
And the date of that signature again, please.
It doesn't say.
For the top of the page for the filing date, Brendan, please.
It was filed on May 7th, 2020.
Offer proposed exhibit 3734.
Okay.
Brendan, can I have state's proposed exhibit 3400?
What number, council, sorry?
I have it as 3400. Can you describe this document, Ms. Parker?
This is a proof of completion of work filed with the state engineer's office on September 6th, 2007. and Mr. Savely filed this on behalf of Coyote Springs Investments related to permit number 74094.
And remind the court what permit number 74094 was.
It is one of the permits that is abrogated from 46777. And I believe it is a permit that now some or all of the water under that permit is owned by the Coyote Springs General Improvement District as we sit here today.
And how much did Mr. Savely indicate had been spent on the project as of that date?
At least $1,200,000 has been expended in work or performed or improvements made to develop water as set forth under the conditions in permit number 74094.
And if you could read into the record the improvements upon which that 1.2 or at least 1.2 was based.
Said improvements consisted of a 20.625 inch inside diameter, 0.375 walled casing, completed to a depth of 1,147 feet and equipped with a 8-stage intersole dresser, 14 NKH line shaft turbine pump, serial number 1414 EC-1354-05-2006, powered by a 900 horsepower Detroit diesel engine until permanent line power can be delivered to the well site set at a depth of 800 feet. The 12-inch diameter discharge line is equipped with a 12-inch diameter micrometer propeller flow meter. Initial meter reading of 68053 at the completion of the pump installation on June 1, 2007. Said work being essential to the actual diversion of the water applied for and required under said permit. The works of diversion were completed prior to June 1, 2007. The point of diversion is located within the southwest southeast quarter of Section 10, Township 13S, Range 63E, MDB &M. Well drilling contractor, Lane Christensen Co., 11001 Etowanda Ave, Fontana, California, 92337, Nevada Contractor's License number 0019101.
Offer state's proposed exhibit 3400.
No objection, Your Honor.
No.
It's in?
Yes.
Okay.
Again, and again. Friend may have state's proposed exhibit 3460. The last one we just looked at was 2007. This is now September of 2010. Does it relate to the same permit number we were just looking at?
74094. The proof of completion we were just looking at, I believe, was for 74094.
Go back to that one just to for clarity of the record 3400, Brendan.
Yes, 74094.
Okay, and that's the one you think was the transfer to the GID?
Yes, as the extension of time describes the bifurcated ownership that we flip back to the other document.
Okay, if we can go to then 3460, Brandon, again. And explain to the court what this document is.
It is an application for extension of time, and it shows the owner of record is the Clark County Coyote Springs Water Resources General Improvement District for 750 acre feet, and Coyote Springs Investment LLC for 250 acre feet, related to permit number 74094. And this was filed by Mr. Savely.
This again is a portion of the water that came from the base permit.
Correct.
And if we can go to the item number 5, and it advised the court how much CSI advised the state engineer how much it had spent last year and the total to date on that particular permit.
For permit 74094, last year it says production costs only. And total to date, $1,115,559.
Is there an attachment to that document? I'm sorry, if you would read into the record the scope of work for the project, I should say.
Item number 7, the state engineer issued cert number 17035 under permit number 70429 on August 28th, 2008. CSI, on behalf of both owners, filed a proof of beneficial use under permit number 74094 on December 16th, 2009. However, the state engineer advised CSI to withdraw the PBU because the state engineer would not issue a certificate under 74094 because this production was in lieu of production under 70429 rather than in addition to such production. To date, the water used by CSI in the development has been used for golf course and landscape irrigation, dust control, and other construction water needs rather than typical municipal uses. By letter dated December 28, 2009, the PBU was formally withdrawn. Because the state engineer is requiring beneficial use of this municipal water to be in addition to previously certificated rights, a period of 5 years is needed to place this water to beneficial use. The project is subject to recorded development agreements with both Clark County and Lincoln County that anticipate a 40-year build out.
And you talked about this document, I believe, on direct examination, where the state engineer refused to or declined a application to establish beneficial use because it wasn't, and the CSI wasn't using the full amount of the certificated water, but was instead attempting to establish beneficial use for the same purposes that certificated water was previously put.
I'm not sure that's how I described it. I do remember talking on direct exam about the documents that Mr. Savely had filed and that what he had said about that. I don't recall specifically what I said, Mr. Sylvester.
Okay. But again, you're talking about, when I say you, CSI is advising the state engineer about the recorded development agreements with respect to the master plan community in both Clark County and Lincoln County. Is that a fair characterization?
That's one of the statements that Mr. Savely included in this.
I'm fairly certain it's been admitted. If not, I would offer 3460. Thank you. Frank, can I have state's proposed exhibit 3519? And enlarge it if you could. And this is an application for extension of time. And this is dated, looks, it appears to be September 17th, 2015. And it relates to permits 74094. Did I read that correctly?
Yes, you did.
Okay, and this is a continuation of the prior application we saw a moment ago.
Yes, it is. It's filed on behalf of the Clark County Coyote Springs Water Resources GID and Coyote Spring Investment.
Okay, once again, let's go through the same process. Item number 5, the expenditures.
The expenditures on this permit in the last 5 years, Mr. Savely notes, were $843,692. And the total to date under this permit, $1,959,251.
And the scope of work, please.
Number 7, to date, the water has been used for golf course and landscape irrigation, dust control, and other construction water uses. Construction of the Clark County Coyote Springs Water Resources GID treatment facility has not been completed. Subsequent to the issuance of certificate 17035, parenthetical, permit 70429, and parenthetical. The state engineer advised CSI that another certificate will not be issued until the water was used for additional municipal purposes. In June 2015, the pending litigation between CSI and Weyerhaeuser NR Company was settled. As a result of the settlement, the WNRC and WNR Coyote Holdings property was purchased by Coyote Springs, Nevada LLC, parenthetical CSN, and parenthetical, an affiliate of CSI. CSN will be the developer of the project and it is currently pursuing engineering and construction service is subject to recorded development agreements with both Clark County and Lincoln County that anticipate a 40-year build out.
Offer proposed exhibit 3519. Thank you. Brenda, may I have state's proposed exhibit 3745? And Ms. Cardle, if you can identify the document, please.
This is an application for extension of time for filing proof of beneficial use, and it's a form that states manner of use, municipal or quasi-municipal. It is for permit 74094. And it is filed on behalf of Coyote Springs Investment.
And when is it filed?
I cannot see the stamp on it.
Let's go to the signature page, Mr. Sabling. It may show the receive date above the signature.
Yes, it says received September 11th, 2020.
Okay, so as of 2020, as it relates to this permit, the CSI is indicating to the state engineer that the total amount spent on the project is $2,032,295. I'm sorry, $295.
Total to date, yes.
And the item number 8 indicates what the project or what the work has been completed with respect to the amount of money expended. Is that accurate?
Yes, and there was a supplement, I think, attached as well.
Okay, and we can look at that supplement actually at page 2 of that document, and it says describe the progress. If you just read that into the record.
The number 17.
17.
I mean, is that what you want me to read? Is this number
Yes, please.
17?
Mhm.
The water treatment facility was completed and tested. However, it was not accepted by the Las Vegas Valley Water District, the manager of the GID that will ultimately own and operate the facility. Time is needed to satisfy the state engineer. There is a sustainable water source in the basin to satisfy permitted appropriation. Time is also needed to resolve the pending litigation in Clark County District Court and the 7th Judicial District Court, and to address issues resulting from Order 1309. Final maps for residential development were submitted, but at this time, approval of the maps was denied.
The water treatment plant was completed at, do you recall generally what the cost to CSI was to complete that water treatment plant? Best estimate?
We would need to look at the contract because it included the wastewater treatment plant as well between HDR and Meadow Valley, but I believe it was in the somewhere. It was less than, I believe, $20 million.
But that cost and expense with respect to completing the wastewater treatment plant is not reflected in the total to date at 0001. They're different things. Is that accurate?
The wastewater treatment plant or you said wastewater just
Whatever
now.
is referenced in the, it appears to be the. Yeah, it says water treatment facility.
I see that. I was only questioning because when you asked me the question, you said wastewater. And
Well, do you know what it's referred to when it says water treatment facility has been completed?
I know what the water treatment facility is. Yes, it's the groundwater treatment facility that takes the water out of the ground and treats it. Yes.
So when you answered my question with respect to the amount incurred, it was related to the amount incurred and expended for the water treatment facility as you defined it, less than 20 million.
Yes, however, as I said, the contract was between Meadow Valley and HDR. And Lane Christensen may have been involved as well, but it was for both facilities, and without looking at the contract and the pay application schedule, I couldn't tell you exactly how much it was without looking at that.
But none of those costs, whatever it comprises the approximately or less than $20 million is not identified for the state engineer in this application as having been expended. Is that fair?
I do not know where Mr. Savely, what he included or did not include.
Okay, but $2 million is less than 20. Do you know if the $20 million estimate that you gave or under $20 million included all or any portion of the $2 million that you advised the state engineer have been expended?
Objection asked and answered. I'll allow it.
I don't know, Mr. Sylvester, what, I agree with you. The 2 million is less than 20 million. I don't know what Mr. Savely included in that number.
Okay. I believe it has been admitted, but offer 3745. Thank you. Can I have exhibit 3858, please? If you can identify this document, please.
This is an application for extension of time filed by Coyote Spring Investments related to permit 70430. And it was date stamped received by the state engineer on May 14, 2009.
And again, if we can look at the item number 5. And advise the court again what how much money had been expended on that permit.
The form number 5 states that last year $204,500 was expended, and the total to date was $2 million for this permit.
Offer 3858. The 10, thank you. We have 3399, please, Brendan. You can identify this document, please.
This is an application for extension of time filed by Coyote Springs Investment for permit 74095. It was filed with the state engineer's office on September 6th, 2007.
And can you explain to the court the relationship of 74095 to the previous permits we looked at?
74095 is another abrogated permit from the base Nevada power permit of 46777.
And so if you would advise the court the total amount of expenditures on the project as set forth in item 5.
In question 5, it says the total expenditures on this project are $1 million.
And how much is necessary to complete the items or the work or the project?
I can't see that on the form. It says approximately $200,000.
Okay, and what is the scope of work in item number 8?
It says currently drilling the well, which was started in September 2006, and have not yet completed the production well and associated hydrologic testing. Anticipate completion of drilling and hydrologic testing during fourth quarter of 2007.
Offer 3399. Thank you. Brendan may have proposed 3421. And identify the document, Ms. Cardinal.
This is a proof of completion of work dated August 29th, 2008. Well, it was filed with the state engineer on August 29th, 2008 for permit 74095 filed by Coyote Spring Investment.
And the amount of money spent in completing the work is that the $2 million?
It says at least $2 million has been expended.
Do you know what the status of the project is as of 2006? When I say the project, I mean the master plan community.
2006,
Yes, ma'am.
the 404 permit to allow to commence was not issued until it was sometime right after I joined the company. So May of 2006 sometime. And at that time, that's when grading commenced for the golf course. That's when that level of activity began, and Pardee was not yet on site building streets, roads, infrastructure. My memory is they were still doing planning and engineering. They may have started some grading. I can't remember right now, Mr. Sylvester. We'd have to go back and look in time. We had just finished kind of the early planning with the detention basin. We being a combination of Coyote Springs and Pardee with the state engineer's office, and that we're working to obtain a permit right-of-way license, I should say, from the BLM. Once we knew what the footprint of the detention basin was that the state engineer had approved at that time. And then that lease with the BLM was ultimately attained by Pardee Homes of Nevada. And that was the mid 2006 was the start of construction.
Okay. And if we were to look at it, I'm going to refresh your recollection if I can. A long time ago, in this cross-examination, we had looked at your direct cost summary. And I think we had agreed that the amounts expended by CSI during the time period that Harvey Whittemore was involved through December of 2007 was roughly $110 million. Do you recall that generally?
Objection, lacks foundation.
Sustained.
Do you recall the document that I showed you on cross-examination? And it was a document prepared by CSI that reflected the amount of money expended chronologically from the start of the project through at least 2022.
The summary sheet that
Yes, ma'am.
Ms. Gardner had prepared.
Correct.
Yes, I know the summary sheet you're referring to.
And do you recall the discussion that we had? I'll show it to you again. I'm happy to do that. Reflected how much money had been expended through December of 2007.
I recall that we talked about that, but somewhere in the past, however many days we have been engaged in this exercise, I don't remember what dollar amount it actually said, Mr. Sylvester.
Brenda, can I have proposed 3848, please? Pardon me?
If that was not in, do you want me?
Which one?
Report you
One more.
want.
Yeah, she said it's like,
Okay.
this is that document you and I were just discussing, wasn't it? Okay. And then we have that first column, and it indicates the amount expended. If you can bring it up, Brendan.
The first column or the first row, Mr.
First row,
Sylvester? So that's through December 31, 2007.
was how much?
Oh, I don't know. I didn't go that far over. I'm just making sure we're talking about the same row.
We are, yes, ma'am.
Okay, if you exclude do the management fees and only include the Clark County dollar amount, you go clear to the right-hand side. It identifies $102,304,266.62.
Thank you. You can take it down, Brent. I have proposed 3547. And we're continuing on, as I understand it, once you get it up, but I don't know what that is. 3457. Okay, we're continuing on the permit 74095. Is that accurate?
Yes,
Okay, and explain this document if you would.
it is an application for extension of time for permit 74095 filed by Coyote Springs Investment. It was received by the state engineer's office on September 3rd, 2010.
And the total to date expended under that permit was the 2,100,667. Is that correct?
Yes, and it says for last year to see attached.
Okay. Let's do that. Let's go to 0003.
And so for last year, Mr. Savely identified 0 for development costs were limited to production expenses.
Okay. Offer 3457.
No objection, Your Honor.
Admitted.
May I have 3518, proposed 3518? Can you identify the document, Mr. Cargill?
This is an application for extension of time filed by Coyote Springs Investment on permit 74095. And I can't see a date stamp on it. It was received by the state engineer's office on September 17th, 2015.
That's certainly the date that is reflected in the notary stamp. Do you see that?
September 16, 2015, yes.
And the total expenditures on the project was the preceding year, the 125,389, and then the parenthetical of 520, 713. The total to date on permit 74095 is the 2,621,380.
Yes, with an asterisk. It appears to me to be an asterisk after those numbers. I don't know why Mr. Savely typed with an asterisk there. Unless there's a footnote that we can't see.
Offer 3518.
No objection, Your Honor.
Admitted.
Brand may have proposed 3746. It's another application for extension of time for filing it. It relates to the same permit number that we've been talking about, 74095. Is that accurate?
Yes, it is.
And if you would read into the record, the purpose for the request for the extension.
In number 8.
Yes.
Subsequent to, I believe that's subsequent, there's a hole punch there. Subsequent to issuance of certificate 17035, parenthetical permit 70429, end parenthetical. The state engineer advised CSI that another certificate would not be issued until water was used for additional municipal purposes other than dust control and irrigation. To date, Clark County has declined to approve a final map for residential development because the state engineer has declined to sign off on a sufficient water supply. Also, NDWR issued Order 1309, which added Cane Springs to the super basin and reduced the annual maximum production in the super basin to 8,000 AFA. Approximately 20 parties have filed petitions for judicial review, and the outcome of litigation is unknown and is out of CSI's control. This project is subject to 2 development agreements with a planned 40-year build-out.
And the expenditures at item number 10 for the preceding year were 13,114, and the total to date was the 269,424. And this, as we.
There's a little plus after that number, it looks like.
And then we can see from the next page, it's received on September of 2020, looks like 2020. And it's signed by Mr. Savely, and again, has the notary stamp of September 8th, 2020.
Agreed.
And then the next, on that same page, at the top of 13, the amount of water beneficially used was the, what's that number?
In the last 12 months, 209,597,711 gallons.
So in the preceding year, that's the amount of water that was utilized by CSI under the various permits. Is that accurate?
Under this specific permit, yes.
It seems that all of the permits we've been looking at relate to the development of the permitted water. Would that be a fair characterization as to what the descriptions have been as we go through these various applications?
Yes, as Mr. Savely has described to me, that's what you're supposed to do.
Right, it's not, it doesn't indicate how much money has been expended in advancing the development of the master plan communities, other than what we see as the development of the water itself. Is that accurate to your review of the documents?
Objection foundation.
Sustained.
We looked at, for instance, a number of different applications, none of which reflect cost and expense, indicating the amount of money for architectural, habitat conservation, engineering, development agreements, land use planning, those types of things that CSI was expending in pursuit of the completion of the master plan community. Is that accurate?
Those dollar amounts don't appear to be reflected. But the words in the form that Mr. Savely provides describe the Coyote Springs community. And
in this case, you have, I recall, indicated that as of at least 2022, CSI has expended 159 million plus in expenses related to the improvements of the master plan community. Does that generally comport with your understanding?
Objection foundation.
Sustained.
As the COO and the general counsel, do you have any understanding as to how much money has been expended in improvements by CSI in furtherance of developing the master plan community?
if with reference to the sheet that we were looking at a few minutes ago, whose exhibit number, I have no idea what it was. That was prepared by Ms. Gardner that we were just looking at. I believe the number of on that sheet that are some of the damages related to this case are in excess of $159 million for the Clark County portion only. I would say that that's what we have included in the damages, and that there are additional monies that were expended in addition to that.
After that summary was completed? Is that what you're indicating?
I'm meaning that summary doesn't include other costs that it only includes what it shows and what we had the support and backup for that's included therein.
Thank you. Do you recall that one of the topics, only if you recall, in the 30B6 notice related to the cost and expenses of the improvements?
I think so.
And Ms. Gardner was initially designated, but she had some personal issues and you had to step in and be the quote unquote the person most knowledgeable, or the 30B6 witness, correct?
I believe that's how we spent the 5th day of my deposition, Mr. Sylvester. Yes.
I think it was only half. So I haven't already done so. Offer 3746, please. Thank you.
Admitted.
Staying with 3746 at 0002, if you could read into the record, item number 18, please.
18, describe your plans for the next year toward completing the proof of beneficial use. Mr. Savely responded. CSI plans to continue working with the state engineer and the permittees in the lower White River flow system, parenthetical LWRFS and parenthetical, to resolve issues surrounding the sustainable quantity of water that may be produced from the LWRFS. CSI intends to continue pursuing its development plans in Coyote Springs Valley.
So this is representation is made to the state engineer after the May 16th, 2018 letter was rescinded. After 1303 was issued, and after 1309 was issued. As we can see in, it looks like subparagraph or paragraph 17, CSI is representing to the state engineer that it intends to continue pursuing its development plans. Is that how you read that?
Objection, argumentative, misstates the document.
rephrase your question.
Sure. But just from a timeline perspective, the May 16th, 2018 letter was rescinded, correct?
Objection, mischaracterizes prior testimony.
It does.
The
May
May
16th, 2018 letter was rescinded pursuant to the settlement agreement, correct?
yes,
1303 was issued in January of 2019, correct?
yes,
Judge, I'm sorry, the 1309 was issued in June of 2020. Do you recall that?
yes,
This is as of September of 2020, right?
yes,
CSI represents to the state engineer that it intends to continue pursuing its development plans in Coyote Springs. Is that accurate from a timeline perspective?
from a timeline perspective.
This is also after Steve Shell denies the map following the issuance of the 1309, correct?
From a timeline perspective, correct.
May I propose 3765 for you? This also is an application to extend the time to file beneficial use relating to the same permit we've been talking about, 74095. And item number 7, your request, CSI is requesting an extension for 5 years. And then item number 10 reflects the expenditures on the project under the prior year's 153,000. And the total to date under this permit is $2,422,994. Is that accurate?
Yes, that is what it says.
Go to the second page, we can see that it is in September of 2021. Is that, did I read that correctly?
I don't see it.
Go to 002, Brendan. Did you read that highlighted portion?
It appears to say September 14th, 2021, yes.
Okay,
It's a little hard to read.
I agree. Now for 3765. Thank you. If you just read into the record, item 18 and 002.
CSI plans to continue working with the state engineer and the permittees in the lower White River flow system, parenthetical LWRFS and parenthetical, to resolve issues surrounding the sustainable quantity of water that may be produced from the LWRFS. CSI intends to continue pursuing its development plans in Coyote Springs Valley.
And there's a supplement at 003. Item number 8. You just read the first 2 full sentences in.
Subsequent to issuance of certificate 17035, parenthetical permit 70429, the state engineer advised CSI that another certificate would not be issued until water was used for additional municipal purposes other than dust control and irrigation. To date, the state engineer and the GID have declined to approve a large lot and a subdivision final map for residential development because the state engineer declined to sign off on a sufficient water supply.
And the last sentence of that paragraph, please.
CSI spans two counties, Clark County and Lincoln County, with a development agreement in each county with a term of 40 years plus renewals, build out.
As of that date, CSI still intends to complete a master plan community over both Clark County and Lincoln County? Yes?
I believe Mr. Savely's referring to the fact that the water under this permit is permitted for each of the two counties.
And then the second, when you say you believe that, is that you're speculating?
I don't know why else Mr. Savely would include that statement in any of these, but for the fact that the water can be used in each of the counties under the permit.
I understand that. I'm wondering if you actually spoke to Mr. Savely. He told you that was what his intent in writing that document was, or you just in a sense speculating as to why there would be any other reason to put that language in.
Objection, asked and answered.
Overruled.
I have not spoken to Mr. Savely about that sentence.
And item number 17. If we can look at the that sentence that begins the previously described order and just read that balance into the record.
The previously described order number 1309, petition for judicial review, involves many stakeholders. And although the 2-week hearing is set for February 2022 in Las Vegas, that does not necessarily signal the quote end quote of the litigation. CSI desires to proceed with its master plan community entitlements, but it has been halted by the state's actions.
May I have states exhibit 132? I'm sorry, plates exhibit 132. I think you saw this on direct examination, but do you recall this permit to change public waters of the state of Nevada?
Yes,
We can go to page 0003. And tell me if you can identify this document.
this is the application to change the point of diversion of a portion of our water from one well to another well.
And that's related to the 74094 permitted water, is that right?
Oh, there it is. Yes. 70429 certificate 17035.
All right, and this is filed for this application. If we go to 004, it is.
I believe on the first page, it's actually, they handily nicely stamped it right in for us on the, not on that first page, on the first page that we were just looking at of the application. Right at the very top, date of filing in the state engineer's office, October 14, 2021.
Okay, but this is different than an application to extend the time period to establish beneficial use. Would you agree with that?
Yes, I would.
You're actually asking the state engineer to allow a change in the point of diversion, and just explain to the court what a change in the point of diversion means.
Coyote Springs was asking to move the water, I believe it's 250, yes, 250 acre feet, as it says in number 2, we were asking to move it from one well, and I think it was from well 2 to well 4, I believe.
And do you know what for purpose?
Because there is no municipal equipment on whether it was being moved from well 2 or well 3 to well 1 or 4. We were moving the water from a well that has no equipment on it because we stopped spending money. We didn't want to then go and equip either well 2 or well 3. So we moved some of the water instead to well 1 or well 4.
But remember that your testimony yesterday was that when you got the denial in 2020 from Mr. Shell, you indicated, at least CSI believed that was the end of the project. It would never be permitted to go forward. You recall that testimony yesterday?
More or less. I don't remember if I said exactly those words. I may have.
Okay.
I don't remember.
So then why are you continuing, or at this point, seeking applications to change the point of diversion of a well?
It has to do with the golf course and watering the golf course and putting the water to beneficial use. At this point in time, 2021, we've retained counsel, and counsel has given us information and provided advice that I can't talk about. And so we were seeking to ensure that the water was put to beneficial use, and we had to move it to a well that had equipment on it. So we didn't.
Sorry.
That's it.
Okay, were you continuing to attempt to develop the master plan community as you were changing the or filing applications to change the point of diversion?
I don't remember what this application said. We'd have to see if Mr. Sabley stated that or anything like that in here.
I'm only asking you as the COO and general counsel as of that date that application was filed. In your view, in your capacity, did you understand that CSI was continuing to develop or attempt to develop the master plan community?
Objection to the extent that the question calls for communication between client and attorney advising at the time.
I'm not asking about any of that. I'm just asking as a COO of the entity if she understood that they were attempting to continue to develop the master plan community as of that date.
Same objection, same caution to the witness.
Overruled.
As I said,
For understanding, not communication, counsel.
at that time, 2021, no. And we were putting water to beneficial uses, I said a moment ago, and taking other actions as advised by counsel.
Just your answer. I'm not quarreling with you. You just said no, it wasn't continuing to develop the master plan community. Is that what you intended by your answer?
Yes, that's what I intended by my answer. I think that's what I intended by my answer.
Okay, let me ask you a much broader question. As of the date that the Steve Shell denial came out after the 1309, is it your testimony before this court that CSI was not taking steps to continue to develop the master plan community in your capacity as COO?
I'm trying not to conflate in my head various advice of counsel across the years with what actions we took and what I can say and not say right now, Mr. Sylvester.
Take your time. I'm just wondering, again, I'm filtering out all of that if you can. If you can't say as COO of the entity that was developing or attempting to develop master plan community, on what date in time that stopped, I'll accept that answer. I'm just asking for your best recollection as to the date, the year or otherwise, that CSI made the determination to stop developing the master plan community.
I think I've testified previously that we were told no in May of 2018, May 16th, 2018. And I believe I have also said that, especially given the information that we've learned through discovery, that decision was warranted, that was.
I understand that, and I don't quarrel with you, but you didn't have that information when that information that came out during the course of discovery, when the determination was made to stop pursuing the development of the master plan community. Correct? Would you agree with that?
I would agree with that.
So in your mind, as the COO, filtering out any attorney-client privileged communications, in your mind as the COO, when did CSI stop pursuing the development of the master plan community?
I don't believe that we spent money to move forward with development and development matters after, other than closing out contracts that we've talked about before, after Mr. King told Mr. Sino III, stop, we're not signing anything, don't spend another dollar. We did not pursue development activities after that point, other than closing out contracts and putting water to beneficial use and doing the things that council advised that be done.
And the email, as I understand your answer, correct me if I'm wrong, I don't intend to mischaracterize it. That email came out by between Mr. King and Albert Sino III prior to the settlement agreement. You recall that just from a timeline perspective?
I don't remember the,
But just ambiguity as to use of came out.
I'm sorry.
Sustained.
Sure. You testified that it was that date when Mr. King advised Albert Sino III, don't spend another dollar for words of like effect. That was your testimony a few months ago, correct?
Objection. The witnesses spent some time answering that question and it mischaracterizes it and is incomplete.
Overruled.
after that time, we did not move forward with any, we closed our contracts out and we did not start any other big infrastructure projects after that point.
And so back to my original question, is it that date, as you've defined it, that it, other than completing the existing contracts, that it stopped pursuing the development of the master plan community?
Objection. Mischaracterizes her prior testimony. Incomplete.
If so, she can so state.
Mr. Sylvester, we've talked about this a lot and I don't remember specifically what I've said before, and I'm concerned that if I say whatever I say now is going to be held without looking at every single time we've discussed this topic before, it all would need to come together. I don't know what you mean by, I think that you and I would probably come up with different meanings of stop pursuing development of the master plan. Does that include preserving existing rights such as filing extensions of time or for anything, not just water permits? Does that include paying the fees to the Bureau of Land Management for an existing lease on the detention basins? I don't know what all your statement includes or doesn't include.
Okay, when I asked you the question, you said, I would ask the same question. You said it was Mr. King sent the email. You didn't quarrel with me as to the definition. I accept your interest in what it is. Did you believe that participating in the administrative process was in pursuit of furtherance of the master plan community?
I'm not sure. We participated, we agreed to participate when we signed the settlement agreement. We agreed to participate in good faith and we did so. We retained consultants as we've talked about, and we attended meetings and we provided comments and we participated.
And in 1309, same thing. You participated, hired consultants and attorneys. Is that in furtherance of attempting to develop a master plan community? If you know.
I'm not sure. I'm not sitting here today now. I don't know.
And when you began to participate in phase 2, when you hired lawyers and others who may have appeared, did you understand that to be in furtherance of attempting to develop the master plan community?
No, I do not think that there's any furtherance of the master plan community.
Can you, without disclosing the attorney-client privilege communication, explain to the court why you have been CSI has been continuing to attend the administrative hearings, the evidentiary hearings, and then phase two, again, without divulging any privileged information?
Checking that question has been asked, well, a series of questions have been asked and answered previously.
Not even once.
This will be the last time. Okay.
But first and last, did you understand the question?
What do you refer to when you say the evidentiary hearing?
I'm sorry, 1309, that 1303 evidentiary hearing that we talked about where the experts came and CSI had that full day.
October of
Yes.
whatever year that was, 2000, whatever year. I don't remember what year it was. There's a big difference between October of, what was that, 2019, 2000 and February of 2026. Which date are you asking me about?
I asked you about all the dates. I'm just asking when you participated in the public workshops and the evidentiary hearing for 1303 and began to participate in phase two, was that in your mind in furtherance of developing the master plan community?
Coyote Springs has water rights within the Lower White River flow system. And we show up and we participate because at the time when it first started, we had agreed to in the settlement agreement. And so we were participating in good faith. We agreed to do so. And now if you fast forward from 2018 to 2026, when the state engineer still hasn't taken any steps and still hasn't done anything other than say, hey, I have the same three options that Mr. King had back in 2017 or 2018, whenever he had that very first meeting in Overton. We participate now upon advice of counsel. It's why I had counsel present with me and why counsel made a presentation. And I can't really disclose other than saying we participated and did so on advice of counsel.
Are you hopeful that there'll be water available at the conclusion of phase two?
No.
Can take our morning recess now and reconvene at 25 to
Thank you.
11.
All rise.
Well, there's our first morning recess. Let's get our notes together. It's been quite a morning, I tell you that. I don't know how you guys are doing out there, but we're doing well. Why do I keep going through this enter a password and then figure out what a stop sign looks like? You guys have to go through that thing? What does a stop sign look like? Looks like a stop sign. Why is the code the exact same? That's pretty crazy. You get two temporary codes that are the exact same code. Here's your verification code that we just sent you. Anyways, thank you for tuning in this morning. We're still continuing our coverage. We are on day nine of the trial, week 3, and we're going to get our notes together so we can put out an update. Are you sure? How many times are you going to ask me if I'm sure? I was sure the first time. You will receive an email with your details. Good. Trying to export a bunch of data that I've been storing for years, and I have to keep going through this thing with social media because social media likes to keep this huge profile on you. So I like to go through every once in a while and I yank everything that I've got and I pull it down and I just wipe out the social media. Let them try and figure out their algorithm off of that. No data. You have your right to request to delete your data, and I just wipe it out. I do my best to keep updated and continue to keep a record of every case and investigation and that type of stuff. But like personal information, it's like you can wipe that side out, bring it back up. All right, in the background here, I got to open up the Book of Faces, also known as Facebook. We'll get our update out there to the world. Today's morning update, Coyote Springs. It is August 12th, my son's 11th birthday. 12 years old. See? We can do it together. All right, let's get this up, see what we can do. Get out our update this morning. What do we got going on in the world today? Fires, that's for sure. Fires, and more fires. A national emergency is declared here in the state of Nevada. Quick update out there for people. I am not anti-AI. I use AI. I use computers. I use servers. I use data. Newsflash, I've been using it for damn near a generation plus, if not longer. It's not new technology. So when I don't want data centers in Urington's backyard or Story County or Silver Springs or Stagecoach or Nye County or Pahrump or Elko or Eureka or Austin, Humboldt, Pershing, when I don't want data centers there, guess what? All of my AI functionality works right now. I want you to know I can make an image, people can make videos, you can analyze things, you can do anything you want right now without any of those systems being turned on and or any more expansion into the state of Nevada, carving up our mountains and our rivers and contaminating the soil, the water, the air, ruining home means Nevada. And why rural Nevada is rural Nevada. We didn't want compute corridors or power corridors or NV Energy or Greenlink or Gridliance or any of these companies running their powerful dreams into these new scaled data set. We didn't want any of that. And their jobs is nothing more than subsidizing the trade industry for the next 5 years to scale and build out these data centers. I've done paper after comparison after like, I'm sorry. It is what it is. The truth is the truth. This is a build to bust speculative market that will 100% leave this state doubled in debt what it stands right now. And then you'll have a huge unemployment hole that is just laid on top of you for the trades work that is not going on. Because at this current status, our state operates on such a tight budget that we truly cannot even handle one more expenditure. That's why anything that goes into legislature or the legislative session has to prove what dollar it spends and where it's getting the dollars from. That's not by mistake. It's because there is legitimately no money in this state. And them bringing this upfront 100 million here or there through memorandums of understanding or memorandum of agreements that they're out there with people and their organizations, nonprofit, non-governmental organizations, local businesses, local contractors, and otherwise that are or have been for 15 years hands out and taken millions and or hundreds of thousands of dollars per these damn entities that literally that's the people you see every time when you go to these meetings at a commission or a planning commission or zoning and they're fighting against you and it's your own neighbor and you're like, what the hell, what do you have to stand? And you find out their business took money through a nonprofit or something or some enrichment program or something has benefit them, and then they shut their mouths. And then they attack their neighbors when they go like, whoa, we're growing, it's good for our community. And you're like, but your water is contaminated just the same as mine is, and your skies are polluted just the same as mine is, and you're like, why are you fighting me? Aren't we neighbors? Isn't this data center going next to your house too? And then they find out so-and-so sold their water rights, sold their house or sold their land, and they're skipping town. They're like, nah. And a great many of the commissioners, they don't live next to this, nor do they see the eyesore. A great many of city council members, they don't live next to it, nor do they see the eyesore. So for them, it's very easy to be like, let me take this money. I'm doing my job as a commissioner or a council member, and I'm just bringing business in. You got another idea for business? You got another idea how to bring jobs here? I'll tell you what you're going to bring to small little towns and rural communities is traffic, and death. Just ask people along the 50 right now with how many damn different solar projects and data center projects and back and forth, north and south through the 95 alternate and the 95. Right there, just people dying every day. Why? Because it's overloaded with traffic. There are 1,000 projects going on at one time at any given moment in any different direction, and people are just running into each other, and they're overworked, underpaid, and they're running into each other out of exhaustion as well. And there are people, I don't know, there's so much that you could talk about in the situation of what's going on out there. It's very saddening. I don't feel great about it, having to report on it all the time. It is a reality that Nevadans face, that people are selling out entire rural communities, and they're pretending as if they're not. That's the thing I think that's most annoying to me, because you can look at it, you can see who's profiting, you can see the people who own construction businesses or environmental permitting or whatever extenuating relationships throughout the years, which they feel as though their family has built that community or built that county or built that town, and therefore they get the say, not you. This is a very gross problem inside of rural communities, where you've got a small bit of people who really believe that they have the power within that community. Even if they were not existing as an elected or an appointed official, they believe that their families built it, their families own it, and they will do with it what they want. And you that just moved there in the last decade or the last generation or the last 50 years, it doesn't matter to them. They don't give two flying Fs about where, unless of course you were born out of Greensboro. If Nathaniel Hawk Mason's wife squeezed you out, you might have a chance in being called a Mason Valley or Urington resident. Outside of that, you're just an outsider and get out of there. Unless of course you join them and you want data centers and you want these things done, then you could be from Oregon, Washington, California, and they'll never call you an outsider, because you're going for their plan to put a massive data center campus and power grid infrastructure to become a GIP. Did you know that they were intending to become a global infrastructure partner for power, and that they're running a gas line right now, and that these road grants and everybody and all these land people changing up land are turning it into literally rezoning and overnight doubling, tripling land value, reselling it to the federal government and or these data centers at exponential rates, making themselves generational wealthy in one switch, and then commoditizing water. Like, we're in the middle of watching a case that specifically goes over water, and I'm consistently having to look through people's filings where they are selling water for millions of dollars, when other down gradient basins and or other families, indigenous tribes, or agricultural people that need and have fallowed their fields for I don't know how long, suffering at the hands of somebody else, profiting off of the public's resource because they believe the paper water is theirs. Paper water needs a reassessment statewide. I would be happy to head that department and go 17 counties and issue fines and put people in jail if that's the case for whatever they've done. I believe there needs to be a water marshal. I'm about to become Rango. Just make me a lizard and let me get out there, because I'm ready to start putting people in jail over this. It's ridiculous. The amount of people, after watching this case and finding out that churches were holding back water rights, and government, like city council, selling off your water rights and your effluent water, and oh, it's all for profit, and we'll get it back in the refill and the recharge. Whoops! We didn't get a refill and a recharge, and the snowpack was down. I guess we're all in a drought. Why are we in a drought? Because y'all keep selling it, when it should have just flowed down the streams, flowed down into the basins, went across the waterways that are connected, by the way. I'm not playing these games with this carbonate rock aquifer and people out there acting like their ignorance of the water is no excuse. There's the same thing. Ignorance of the water law is no excuse. I'm telling you, we're changing this. We're changing it up. We're not going to allow this ignorance to be out there anymore. And it is our water. Do you know that's why you can walk into a gas station and ask for water and not pay for anything? And they have to provide it to you, especially out here in the Southwest. There's a reason, because the water's ours. Look at your bill. Maybe $5 to $8 is your bill for water usage. Look at the delivery charges. whatever nonprofit or non-governmental organization. For us, it's Southern Nevada Water Authority. For you, it may be Truckee Meadows Water Authority. For someone else, it may be Central Nevada Water Authority. You have to understand that those companies are literally making a minimum $20 million a month in fees. Not for water, but they are selling water. That is free, but they developed it. And they spent money to develop that, so they should get money back. But they've made money for 162 years, some of them. I don't understand at what point do we cut off the profitability, understand, like, what would it do for Nevadans, Americans, essentially, to say, you no longer have a water bill, or you only pay the $8. Delivery fees, gone. All this nonsense for building, I want you to look up Southern Nevada Water Authority's building downtown Las Vegas and understand where your fees have been going. And then think about it again and understand that Southern Nevada Water Authority is $1 billion plus in debt, and that's why we can't just end the agreement, supposedly. I don't think that's the truth, nor do I believe that for a second. I believe that the conglomerate that is Southern Nevada Water Authority, Las Vegas Valley Water District, ran by commissioners who have a water board, who then play these games they play, then sell water to California and sell water to developers and sell water to everyone because they developed it, and or they are the retainers and owners of it right now, and or the permit holders. Oh, court back. Here we go.
So I understand. It's pretty up there. It's beautiful.
Being seated, Department 13 is back in session.
No.
Please be seated. We're back on the record.
Yeah. I can speak through it.
Witnesses retaking the stand, you may resume.
Thank you, Your Honor. Brandon, will you put back on the screen 132 just to see where we left off before we took that little divergent path? I believe this document has been stipulated for admission 132.
It's them.
Thank you. We're going to have state's proposed exhibit 3968, which I also believe has been admitted. Just identify it for the record very briefly.
This is a proof of completion of work meter required form filed with the state engineer's office on July 26, 2023 by Coyote Springs Investment. And it says that at least $4,523,000 has been expended to develop water as set forth under permit 91200.
Okay, again, it's for the development of water, that amount that was expended.
Yes, I think this is for well 2.
Okay. It has it at upper 3968.
No objection, Your Honor.
It's admitted.
And the next is plaintiff's 131, please. The application 91201, and it is an approval by the state engineer. And it's at the front page, you see where it says it's permit to change the point of diversion, portion of the waters of an underground source granted pursuant to 74094. And so this is again sort of an abrogation of 74094. Is that correct?
Sorry, I can't.
Yep.
In the second paragraph, it does say that this permit to change the point of diversion of a portion of the water under 74094.
And it also indicates that it is subject to existing rights. Do you see that?
I'm just looking, I'm not disagreeing with you. I'm just saying I can't see where it says that on the page right now.
It says subject to the terms and conditions imposed in said permit, that's the 74094, with the understanding that no rights in the source will be affected by the change in the point of diversion. Did I read that correctly?
No. It says, and with the understanding that no other rights on the source will be affected by the change proposed herein.
Okay, which was a change in the point of diversion.
Yes, a point of diversion, yes.
And it has that same language we've talked about a number of times. We won't belabor it. The state retained the right to regulate the use of that water. On the
Yes,
last,
that's the last sentence of that paragraph.
offer 131.
No,
Go to 39, proposed 3969, please. It's filed July 26, 2023. Again, it's related to 91201 and the amount expended. It looks like is the 4,523,000.
At least 4,523,000, yes.
Again, that's in connection with the development of the water. Would that be a fair characterization?
With the development of that well that water came out of, yes.
Offer 3969.
no objection. Admitted.
States, I'm sorry, plaintiffs 139, please. Second page at 002 is an application for a permit to appropriate the public waters. And can you just identify what that document is and for what purpose it served?
72218. It says the applicant Lincoln County Water District and Vidler Water Company, Inc. make application for permission to appropriate the public waters of the state of Nevada is herein stated.
Okay, and that was granted?
I believe 72218, it was a granted permit, but I don't see that on the page we're looking at.
First page of that document.
Yes, I see that.
Okay, going back to 002. At item number 9 indicates the estimated cost of works to develop that water was 100,000. Is that accurate?
I don't have any idea. We did not file this document. It's accurate what it says. That's what the document states, but this wasn't filed by Coyote Springs.
Does it relate to any of the water owned or controlled by CSI? Is this a portion of the Cane Springs rights?
It is a portion of the Cane Springs rights, and we would need to dive into and look at all the permits on the Cane Springs to see which are now owned by Coyote Springs Investment or Lincoln County Water District or Coyote Springs, and which permits then remain with Vidler for their 500 acre feet of water that CSI has the option to purchase. I'm not sure where 72218 falls, Mr. Sylvester.
Okay. At proposed 3391. This also appears to be at 002, an application filed by, is it Lincoln County?
And Vidler Water Company.
Okay.
Yes.
Again, you don't know whether this is or is not a portion of the Cane Springs water that CSI claims an interest in without additional information.
Permit 72219. It is either a part of the water owned by Coyote Springs Investment, Lincoln County Water District, or a part of the 500 acre foot option that Coyote Springs has the right to purchase. I just don't know which part of it that it applies to.
It just has a date stamped number from CSI. So that's a document that CSI produced.
I agree.
Offer 3391.
No objection, Your Honor.
Admitted.
Brenda, may I have proposed 3754? This is an application for extension of time to file proof of beneficial use. May 30th, 2021, and it relates to permit 72296. It's at 002, it is signed by Mr. Sabley. Do you understand what that permit relates to?
May we go back to the first page, please?
Mhm.
This is for one of the water rights that is owned by Blue Mountain Ranches of Nevada in Lincoln County. And I think it is one of the what we've been referring to as the Tuffy Ranch water rights, of one of the many permits that are related to the Tuffy Ranch water rights.
Okay, and if we look at 003, it discusses in the first paragraph the water capacity agreement that we've talked about before. Do you recognize that generally?
Yes, I can see that. That's what it just, Mr. Sabley is discussing that process.
In the in that paragraph, it seems to indicate that, well, it does state that the groundwater development project, the SNWA groundwater project, was canceled in 2020. You see that in the middle of the paragraph?
Yes, I do.
Okay. And the last full sentence, you could read that into the record, please.
Once there is a final route determination, one or more rights of way must be obtained from the Bureau of Land Management before construction can begin, which is anticipated to take 2 to 3 years to complete.
Is that the pipeline that CSI intended to build in as much as the SNWA pipeline was canceled?
I think we need to read it in light of the sentence immediately preceding that, because I believe the 2 to 3 years that Mr. Sabley is referring to is the prior sentence. CSI needs time to fully evaluate other pipeline options and routes to deliver water to Coyote Springs, and will do so in conjunction with various third parties, consultants, and others, including Lincoln County Water District.
But that's consistent with what we've talked about before, which is SNWA had indicated, CSI had indicated that even if SNWA pipeline was not completed, CSI would attempt to finance and build its own pipeline to bring that Tuffy Ranch water down. Would that be a fair characterization of that paragraph?
No, I think it's not. I think that it is CSI is at this time, the date of whatever this was, I don't remember right now, was fully evaluating. They needed time to evaluate and look at some of those options.
Sure, I don't disagree with the language. It says CSI needs time to fully evaluate other pipeline options and routes to deliver water to Coyote Springs, and will do so in conjunction with various third parties, consultants, and others, including Lincoln County's Water District. Did I read that correctly?
You read it correctly.
So is it fair to say that at least at that time, after 2020, CSI was considering other pipeline options to bring that Tuffy Ranch water down?
Coyote Springs was considering evaluating those options, yes.
And again, to remind the court when this application was filed and those comments were asserted.
I don't remember right now.
First page at 001.
2021.
Why, if it wasn't attempting to continue to develop the project, was in 2021 CSI representing to the state engineer that it was continuing to look at, or beginning to look at options to bring that water down, if you know?
Conversations between Mr. Sabley, Mr. Sino, and myself are privileged on that matter.
I'm only asking, and maybe you already give me the answer, outside of a attorney-client communication, do you as a COO and general counsel have an understanding as to why, if the project had been terminated or canceled by the state engineer, it was at that point looking for options to bring that water down? Again, not divulging any privileged information.
I don't believe any communications were had that were not privileged communications on that topic, Mr.
So you
Sylvester.
would have, my apologies, you wouldn't have a foundation without disclosing a privileged communication. Is that an accurate recitation of your testimony?
Yes, it is.
Okay. If you just read into the record, paragraph 17 at 003, please.
Okay. Is there anything on the other page other than C supplement? I'm not sure if I'm missing out on any prior sentence.
Sure,
Sometimes Carl will include one or two sentences and then say C supplement.
Yeah, I want you to be fully informed, so we'll look at 001
Nope.
first.
I agree. He's just said C attached supplement.
Okay,
Thank
and
you very
00
much.
I'm sorry, 002.
Yes, he just said, sometimes he puts actual text there,
Okay,
Mr.
I just
Sylvester.
want to make sure that you're not misled with respect to what the document said. So if you're comfortable, go forward and read paragraph 17, please.
CSI prepared an Atlanta raw water tie-in to SNWA pipeline. CSI and Lincoln County Water District prepared 1, a culinary water capital plan, 2, a street facilities capital improvement plan, 3, a wastewater capital improvement plan, 4, a secondary capital improvement plan, and 5, a stormwater capital improvement plan. Water conservation measures were adopted. Preliminary engineering for the drop points from the SNWA pipeline to the Coyote Springs development was performed. Until the time SNWA canceled the groundwater development project in 2020, CSI and LVVWD excuse me, that should say Lincoln County Water District, not LVWD. We're relying on SNWA's engineering, design, financing, and construction efforts. Upon cancellation of the project, CSI has begun discussions to evaluate potential alternate routes to deliver water to Coyote Springs with appropriate third parties.
And then the note, please, if you would, at the bottom.
Note, Blue Mountain Ranches of Nevada, parenthetical BMR and parenthetical, is the owner of record of this permit as it is the base permit for supplement permit 79106 at Lake Valley Farms as the farm and the appurtenant supplemental irrigation permits were conveyed to BMR. However, all water appropriated under permit 72296 will be utilized at Coyote Springs.
Will be utilized. Is this application and supplement consistent with your understanding as a COO that CSI was not pursuing development of the master plan community, again, without divulging any privileged information?
It's not inconsistent. Mr. Stabley is simply stating what the permit says in that sentence.
But when he says will be used, it sounds like that's prospective. Would you agree with that?
Objection, argumentative.
I'm just asking if she agrees with the will be used is a prospective concept or at least statement.
Overruled.
Mr. Sylvester, I don't want to argue with you, but to me, Mr. Stabley is simply referring to what the permit 72296 states. It states that the water will be utilized at Coyote Springs.
Offer proposed 3754.
No objection.
Before we look at additional permits, let's see if we can break it up a little bit. I want to return to admitted exhibit 353A, please. That's that email course that whatever it is, statement, memorandum related to the Concord. Potential land swap. Do you recognize it from having seen it yesterday?
Yes, and this is the document that I said, I don't remember it. I think that's what I said yesterday, something along those lines. Even looking at it today, I still have the same comment. I recognize all the words in it, but I don't know that I prepared it. If I did, I have zero remembrance of it.
We, I recall your testimony, correct me if I'm wrong, that you couldn't recall. You do recall that there was a potential land swap that was contemplated by CSI, and you had some limited involvement in that discussion or discussions. Is that accurate?
I don't remember saying it quite that way. We had discussions, meaning Coyote Springs, Mr. Sino and I, Mr. Whittemore and I, in some of us, sometimes the three of us together, and at times, I think the first time was just Mr. Whittemore, myself, and one or two others. And then later, Mr. Sino, myself, and maybe one or two others. We went and we met with base commanders at Nellis. I never had any involvement in discussions with anyone at the Concord Naval Weapons Station or with the city of Concord or with Department of Defense related to specifically related to the Concord Naval Weapons Station. My discussions were always on the Nellis Air Force Base side.
Do you know the name Michael Esposito?
Oh, I remember his name, yes.
And who is Mr. Esposito?
He was a consultant that Mr. Sino III had recommended to him, meaning some city in Northern California had used Mr. Esposito as a consultant. And that city recommended to Mr. Sino III that Mr. Esposito be hired because he was good at what he did on a federal level. And Albert Sino III had Coyote Springs retain Mr. Esposito. I believe that Mr. Sino III's company or one of the other California companies may have also retained him, but it was due to someone that had referred him to Mr. Sino III, and Coyote Springs retained him, had him retained for in my view, a very short period of time, and terminated his representation.
Okay. May I approach Madam Clerk with an exhibit 4016? Under the terms of our stipulation, to the extent that it hadn't been previously marked, we can supplement the exhibits with paper copies rather than electronic copies of the exhibits. If I may provide one to council, which has been provided in advance. May I approach Madam Clerk, Your Honor?
Yes.
The 4016. Is this my copy or is this?
I have one for the witness as well.
Okay. I've seen this.
May I approach the witness? Your Honor?
Yes, what's the number on it?
It's 4016. Ms. Carlo, I'm showing you a series of emails that were produced by CSI of this litigation. It begins at CSI 6, the date stamp CSI 602068. And
Your Honor, just my one comment or objection is just to clarify for the record. Is this just being produced to us now? Was this produced previously in the vault or
Just now.
it wasn't put in the vault.
it was not? Okay.
That's right.
Okay, so this has not been previously produced to us. Or, I mean,
You produced.
we produced it, but it wasn't on any of your exhibit lists and it wasn't put in the vault.
Correct, and our stipulation is on cross-examination to the extent that we need additional documents that haven't been placed in the vault that we could utilize that in cross-examination. By providing a paper copy.
Okay, at the time of the examination.
Right.
Okay, so the way that I'd like to just handle this is, I can't remember what the stipulation says, counsel. I'm accepting counsel's representation that one of the things that we agreed to was that if you need on cross-examination to use a document that has not been listed on one of the parties' exhibit list and not been provided into the vault, that it can be used by providing counsel with a copy at the time of the examination. I'm just accepting counsel's representation on that, Your Honor, and we can move forward on that basis. If that's not the case, then we can revisit this.
That's my understanding as well, Your Honor. If I've got it wrong, then Mr. Hudson and I will reconvene and discuss how to resolve it if at all. But my understanding is that we could use documents that will either party listed may call or will call to the extent that it's necessary in a cross-examination. So we can work that out if necessary, but we don't need to delay the proceedings subject to that agreement.
I'm accepting counsel's representation on it, and then we'll proceed it from there.
It's a series of emails by and between, among others, Mr. Esposito. I just want you to turn to um 0040.
All right.
Just if you go one page to 0039, you will see the reference of March 22nd, 2017. The next page indicates it is an email that you sent because it bears the name Amelia. Just tell me first if you recognize the document, and it's over your signature block as the COO, Senior Vice President and General Counsel.
Yes, I do. I mean, I see the email and I don't remember it per se. I see it and I see it has my signature block and it appears to have come out of Jeannie Pavo's emails or files.
At 0040, you indicate at this time we have 3 key projects. And if you just read those 3 key projects into the record, please.
Number 1, the Coyote Springs, Lincoln County reconfiguration, aligning the BLM lease lands with the Coyote Springs Conservation Corridor per our Habitat Conservation Plan. This is our primary concern. Number 2, the potential swap of Coyote Springs for the decommissioned Concord Naval Weapons Station. Number 3 is purely an Albert III item. I will just put that as a side note. I know nothing about it. The swap in Pittsburgh, California, referred to as quote Stoneman, end quote. We agree with you. This is not an all-inclusive list, and there will be other projects that come along from time to time or that stem off of these projects.
So the second point, is it fair to characterize that as being the Concord potential swap that we've been discussing in connection with the exhibit?
Yes,
Okay, so does that refresh your recollection that you had some involvement as of March 2017 in a potential land swap with Concord?
Mr. Sylvester, I don't think I said I didn't have any involvement. I said I never met with anyone outside of Nellis Air Force Base personnel. I never met with anyone in Concord or at the Department of Defense that was specifically assigned to or tasked on the Concord Naval Weapons side. My involvement was at the Nellis Air Force Base and with persons that either came to Nellis or I met because of that Nellis relationship.
Okay, was it a key, to your knowledge only, was that one of the key one of three of key projects that were then being considered by CSI?
These were the projects that were being given to, at the time, Mr. Esposito to attempt to assist with.
Was Mr. Esposito retained to assist with the Concord swap?
It looks that way. I don't remember. I had not remembered that.
But with the conditions, the council and I have placed on the record offer 4016.
Your Honor, can I just, and Counsel, can I just have a chance to review this, maybe at a break or something, and then I'll be happy if I don't have an objection to place that on the record, but just hold that in advance for now, Counsel. Is that all right?
Yeah, I have no problem with that, Your Honor.
Thank you.
And one of the reasons I orient you in time is you included in one of your previous answers on that same topic that perhaps Mr. Whittemore was involved in those discussions. That's how I understood your testimony. Was that your recollections at the time?
I recall we vaguely talked about that, and I believe I referred to the 2010 time frame.
Okay.
And that's just a memory I have, Mr. Sylvester. I could be mistaken, but that is my memory, that that's something that was discussed.
Just having looked at that, one of the three key projects being the conference walk in 2017, refresh your recollection that Mr. Whittemore wasn't involved in those discussions.
Not necessarily, meaning it didn't happen in 2010 timeframe. And so perhaps we did discuss it and then the conversations were still continuing in 2017.
Just from a timing perspective, and I'm gonna test your recollection, only in the documents in this case.
That's all you're gonna limit it to? Really?
If you're and I'm gonna take you back only to 2017, your first meeting with SMWA, where they initially presented to you that PowerPoint presentation was March 17th, 2017. Does that comport with your recollection?
March 2017.
Right.
Mhm.
Yes.
Yes,
And this is 4 or 5 days after, at least from your email. I think it was 040, Ms. Carter.
March 22nd, 2017. I agree with the date.
Thank you, Ms. Carter. I'm just closing some loops on a few of those before we get into some more permit reviews. Cleanse your palate. Brittany, may I have states proposed exhibit 3773? Do I have a copy of that? 3773.
So for support,
Pardon me?
what is the trial exhibit you're trying to pull up?
3773. It should be a Board of Equalization transcript. There you go. Tab 196. 196. So do you remember appearing before the Board of Equalization? If you turn to 3773002. Do you recall appearing before the Board of Equalization in and around February of 2022?
I don't remember specifically. I have appeared before the Board of Equalization a number of times.
And for what purpose? On behalf of CSI?
This says it was on behalf of Coyote Springs, Nevada, and it would be to challenge the values that are placed on the property by the assessor.
And do you recall for what purpose Coyote Springs, Nevada was challenging the assessment? Is it for tax purposes?
Assessment purposes, we would be challenging the assessments, which then through a complicated formula become the amount that your property is taxed.
Okay. And you testified at that Board of Examination or Board of Equalization hearing, do you recall?
I believe I was the whatever you call it, the protestant, the person who filed the appeal, myself and probably Mr. Steve Lichty, Lichti, from Mr. Sino's Concord office. And I'm the one who filed the appeal and I'm the one that made the appearance and presented the materials.
If we can turn to 0042 of that document. And at line 26, this camp is described It says, so Ms. Camper, this is, I think, from you, starts with you. Yes, there is. Ms. Camper described, again, we're going to talk about the 2020 REPI proposal. And that I described last year was I don't disagree with any of Ms. Campa's facts. That's how you
I
think.
believe it's Mr. Campa, Troy Campa, who was the presenter on behalf of of Clark County. I believe it's Mr. Campa. I believe that transcript is correct.
You are correct. It's Troy Campa. Just read into the record at 20 through 25, if you would, please. And again, the 2020 REPI is what we looked at yesterday. You recall that?
I didn't remember it was 2020 until just reading this right now, but okay.
Okay, just read into the record 20 through 25.
Ms. Henson contacted me in January of 2020 and asked if the owners of Coyote Springs would be interested in having a communication about the possibility of selling Coyote Springs or donating part of it or having an easement across part of it for conservation, for overflight, for a variety of different purposes.
Okay, and just continue on to the next page, please. Keep reading.
A part of this communication was Mike Ford. Mike Ford helped make that introduction, and he has done several of these processes before through the Conservation Fund. I've known Mike many, many years. I said, okay, I'm willing to have this conversation. I talked to the owners. Mr. Sino said, so long as it's for a fair market value, so long as it, if it includes the water rights, that there is a fair compensation for the water rights, so long as it is a negotiation. I'm not simply going to take whatever number they offer. I was clear with Ms. Henson at that time. At no time did I say, yes, we'll just take whatever comes along. I wouldn't have had my job since 2006 working for the Sino family if that was how I did business. That's not how they do business. They don't own all this land because I get rolled over everywhere I go. I never said whatever goes we'll accept. It was a negotiation. I knew the county had to go and get an appraisal. I knew this was a grant application, but this grant application came out. Our discussions had been the grant application is going to be submitted. It's not going to include water rights. It's only going to be for the land, and the value I was told was not 35 million. It was, I have always said, it has to be well in excess of $100 million. The first time I saw 35 million was on, I believe it was the week that the agenda was posted, that it was sent to me. So whatever, 7 days before the hearing. That's when I spoke to the owners. We talked about it, and I sent a letter that said we declined to further participate. Because at that point in time, even though we were in the midst of trying to figure out what we're doing with the water, 1309 had not yet been issued. There was a lot of stuff going on. We believed that we would be able to develop our property. June 15, everything changed. Intervening, superseding Government Act Order 1309. So yes, in April, we did believe our property was still worth somewhere probably closer to $300 million, especially if you include the water rights. Absolutely. Water rights. What are water rights worth? $10,000 an acre foot, $20,000 an acre foot? I don't know. In the lower White River flow system with some sort of senior priority, probably 25,000 an acre foot. That's a lot. 4,000 acre feet of water.
Next page.
We're not going to agree to 35 million. So yes, with he declined to participate at 35 million. Yes, we believed at that moment in time that we still believe our property is very valuable. It's simply we have to fight through where we're at right now. Mr. Sino believes if he were standing next to me shoulder to shoulder right now, he would tell you, yes, I'm going to be able to develop this property. He's 77 years old. He would stand here and tell you, I intend to develop this property before I die. My yardstick is not done yet. That's what he would tell you. We can't right now. That's all I'm saying. Right now, we can't. I'm not saying I'm not here asking, I want a reduction for the infinite future. This is 1 year at a time, as we all know. Next year, things might be different. I hope next year things are different. I hope the judge strikes down 1309 and by some miracle, no one challenges it. And now I'll be racing back to the state engineer's office with those Mylars that are in my car that weigh 35 pounds. We want nothing more than that. Thank you. That's all.
Is it fair to say that 1309 had been issued, correct?
Yes, it had been.
And at least Mr. Sino believes that the property, even after the issuance of 1309, still had value. Is that accurate? When we were reading the testimony?
That's what my testimony said at that time.
I'd offer state's proposed 3773.
As a public record, no objection, Your Honor.
Admitted.
It also indicates from my review of the transcript that you read that as of that date, Mr. Sino still intended to go forward and develop that property before he died. Is that your understanding from what you just read into the record?
Yes, it is. But I was also standing up asking for a reduction, a very large reduction in value, because at that time, we had been told there is no water and we can't develop the property. And I was asking the Board of Equalization to take that into consideration and reduce the values at that time.
Is it granted?
I cannot remember, Mr. Sylvester, if it was granted. I did a successive series of those. Some may have been granted by Clark County. I know I think twice appealed to the State Board of Equalization. I don't remember which were granted and which were not, and which I took to the state.
Thank you, Ms. Fern. Switching gears again, changing the topic. If I can have proposed exhibit 3819, please. And Ms. Carter, this is correspondence dated July 27th, 2023. It appears to be signed by you at 0003. You turn to that page, that's your signature?
Yes,
And it's a letter that is directed to Nevada Department of Transportation,
yes.
to a Tracy Larkin. And do you recall, first of all, have you reviewed this letter? Would you like a moment to look through it?
No, I'm aware of what this letter is.
Can you tell the court for the purpose of what this letter was sent?
The Nevada Department of Transportation, two individuals that work for Ms. Larkin Thomason called me prior to this. This may have been the second or third grant that Nevada Department of Transportation attempted to get. I can't remember. And they had called me, I believe it was years earlier to this, maybe 2020, 2021, and had said that they, Nevada Department of Transportation, were working to get a grant from the federal government in order to install tortoise exclusion fencing north and south along US 93 through Clark and Lincoln County. And they were asking Coyote Springs for a series of in-kind contributions, help as it were, because Coyote Springs has provided Nevada Department of Transportation a place to park equipment. We've given them water for dust control for their various projects in the area, things like that. And so these two individuals came to me and said, could you give us some in kind? They asked for dust control water. They asked for my assistance to help with a sign that the Lincoln County Authority on Tourism has on the Lincoln County side of Coyote Springs, where they have a small little digital sign, and they wanted some words on it that supported their tortoise fencing and, keep tortoises safe, don't run over a tortoise, call us if you see a tortoise kind of thing. And they also wanted us to put some information and signs on a kiosk that we, Coyote Springs Golf Club, have in our parking lot at Coyote Springs. And that may be all the things that they were asking us if we could help, and they wanted a letter of support saying, demonstrate Coyote Springs that you're willing to help us with all of these endeavors. And so Mr. Russell and I had met with these individuals at Nevada Department of Transportation, and we agreed that that was things that we could do to help with that project. I discussed it with Mr. Sino when it was first brought, when we first did the meeting. And as I say, my memory is 2021-ish or so, Mr. Sylvester, but I could be wrong about that. And so then they gave me the individuals that they wanted me to send letters of support to. And they had kind of a format, and they asked me to then take it and work it into a letter that I would be willing to prepare and sign. So we took their format, we worked it into a letter, and we sent letters off. I recall that there was a letter to someone on a federal level, and I cannot remember who it was or what department it was in the federal government.
And can you just explain to the court how you defined CSI's master plan community as of July 27th, 2023 in the first full paragraph, please?
I will just read what is
Okay.
written. Coyote Spring Investment, parenthetical CSI, and parenthetical, owns the Coyote Spring Master Plan Community in Southern Nevada. Parenthetical, the Coyote Springs MPC, and parenthetical. The Coyote Springs MPC spans 2 counties and encompasses more than 43,000 acres. Coyote Springs MPC is a fully approved and entitled master plan community with 40-year development agreements in 2 Nevada counties, Clark County and Lincoln County. These development agreements allow CSI to develop 110,000 residential units, associated non-residential, commercial, recreation, community facilities and infrastructure, and industrial, and 9,000 acres of renewable energy generation in Lincoln County, Nevada, and allow CSI to develop 49,600 residential units, associated non-residential, commercial, resort gaming, recreation, community facilities, and infrastructure, and industrial in Clark County, Nevada.
And that's an accurate description of the master plan community as of that date. Is that fair?
That is an accurate description of the development agreement in Lincoln County and the development agreement in Clark County, yes.
And Brendan, if I could have the plaintiff's second amended complaint for damages and demand for jury trial at proposed exhibit 3929, please.
We'll meet that one first.
I'm sorry, move to it, offer to admit proposed exhibit 3819.
No objection, Your Honor.
Admitted.
And we didn't look at this one earlier when we started this process a day or so ago. This is the plaintiff's second amended complaint for damages and demand for jury trial. And you've reviewed this document before, have you not?
Oh, yes, it would have been a long time ago at this point, but yes.
Okay.
It's been superseded.
Being amended?
There's the operative complaint is now the third amended, so this was superseded and replaced.
I understand. I'd offer 3929.
Your Honor, as part of the record of the court, I have no objection for that purpose.
Admitted.
So if you turn to, and again, this is the second amended complaint. I think we looked at the first or the original complaint, the first amended, and then we saw the third amendment. But let's just back up and look at what the plaintiffs alleged at that time with respect to the master plan community and the scope of the alleged taking. If you would turn to 002, please. And again, in your capacity as general counsel and COO, you would have read this document at the time, at about the time it was filed, at least for factual accuracy. Would that be fair?
Yes, I would have read it, and Mr. Coulthard would have made the decision about what to file or not file.
I'm just asking about the factual information. We'll get to the claims for relief in a moment. Read paragraph 1 in its entirety, if you would, please.
You're testing my voice. I'm gonna have laryngitis worse than I do.
No disrespect, but better you than me. And for you.
One, plaintiffs, Coyote Springs Investment LLC, a Nevada limited liability company, parenthetical CSI. Coyote Springs Nevada LLC, a Nevada limited liability company, parenthetical CS hyphen Nevada, and parenthetical. And Coyote Springs Nursery LLC, a Nevada limited liability company, parenthetical CS hyphen nursery and parenthetical. And when referred to together, CSI, CS Nevada, and CS Nursery shall be referred to as the CS hyphen entities, each of which such entities were formed under the laws of the state of Nevada and collectively are the owners of all of Coyote Springs, a master plan development measuring roughly 42,100 acres located in both Clark and Lincoln County, Nevada. A portion of Coyote Springs land measuring approximately 6,881 acres has been planned, designed, mapped, approved, and partially constructed as a major project in Clark County, Nevada, along with an additional 6,219 acres managed by CSI of designated conservation land subject to a lease from Bureau of Land Management. Certain of the Coyote Springs property located in Lincoln County has likewise been planned, designed, and approved for development by Lincoln County, Nevada. Coyote Springs is located approximately 50 miles north of Las Vegas, Nevada. As a critical and necessary part of its master plan development, the CS entities also own certain acre feet annually, parenthetical AFA and parenthetical, of certificated and permitted Nevada groundwater rights in the Coyote Spring Valley.
Was that consistent with your understanding as to the scope of the master plan community, at least as of the date of the second amended complaint?
It accurately describes the Lincoln County and the Clark County development agreements. Yes.
Master plan community was my question. Does it accurately describe the scope and extent of the proposed master plan community?
I don't know where Mr. Coulthard defined master planned. We would just have to find where he defined that to see what he actually meant by that defined term, because he capitalized it. And sitting here today, I don't remember how he defined that, Mr. Sylvester.
If you go to 003, please, and read item number 6, at least where it stops after the second full sentence.
This lawsuit was initially filed in the 8th Judicial District Court, Clark County, Nevada, where venue was proper, as the Coyote Springs development and its approved Clark County major project under Clark County Code Title 30 is located in Clark County, Nevada. Certain is, where did you want me to go read to?
Keep going, please,
Okay.
to the next sentence.
Certain of plaintiffs' real property related thereto, which was likewise wrongfully taken by the state, is located in Lincoln County, Nevada.
Did you understand at least from reading this document that the CSI was alleging that the state engineer's action had constituted a take of both the Clark County and Lincoln County portions of the property?
Objection, foundation.
Sustained.
As the COO and general counsel, having reviewed and approved this complaint, did you form an understanding that CSI was alleging that the actions of the state engineer related or resulted in a take of both the Clark County and Lincoln County property?
I understand that's what the words in this document say.
At 004. You read item number 7 into the record, please.
Did you say item number 7?
Yes, ma'am.
Okay. Coyote Springs, Nevada is a master plan community being developed by plaintiff CS entities in Clark County and Lincoln County, Nevada. The Coyote Springs property in its entirety consists of roughly 42,100 acres or 65 square miles, located approximately 50 miles north of Las Vegas. It is bordered by the Delamar Mountains to the north, the Meadow Valley Mountains to the east, State Route 168 to the south, and US 93 to the west.
And at 006, if you would read into the record, the first full sentence of paragraph 10, please.
Did you say the first full sentence, Mr.
But
Sylvester?
I'm going to change directions and going back to 004, if you would, and read into the record, the first full sentence in paragraph 8, please.
For the past 15 plus or minus years, CS entities have completed, submitted, and processed land use entitlements and zoning applications, permits and approvals for its Coyote Springs master plan community in both Lincoln and Clark counties. Did you say the first sentence?
Yes.
Okay.
And to paragraph, I'm sorry, 006, just read into, I'm sorry, we just did that. I can go to 007, please. And read in 14.
14. Many other zoning and land use plan approvals have been similarly pursued by the CS entities and approved for the Coyote Springs Master Plan community by Clark and Lincoln Counties, Nevada. All of the above land use zoning and development entitlements in both Lincoln and Clark counties, when taken together with all other CS entities, approvals and entitlements, will be referred to herein as the quote CS entities' approved major project, end quote.
And then 0025, just paragraph 54, if you read that in, please.
CS entities asserts that the aforementioned acts of the state and its issuance, I think that word is and, application of order 1309 by the state engineer effectuated a total regulatory taking of all of CS entities' economically viable use of the entirety of its Coyote Springs property for which it is entitled to an award of just compensation.
Okay. And when it talks about the entirety of the property, you're referring to both, if you recall, foundationally, both the Clark County and Lincoln County portions owned by CSI.
Objection, Bucks Foundation.
I just
Sustained.
asked, to the extent that you know, you have the foundation to opine as to, in your capacity as both the general counsel who proved factually that the allegations in the complaint and is COO. Did you understand that there was an allegation that the master plan community in total of both Clark County and Lincoln County was the subject of a takings claim?
Objection, misstates prior testimony.
Overruled.
I read number 54 into the record and I understand what it says.
And this was, I think, just for the record, that was filed on November 12th, 2021. Is that accurate?
I don't know.
Okay.
I don't see the stamp at the moment. Yes, I would agree, November 12th, 2021.
Okay. Brennan, can I have state's proposed 3818, please? And tell me if you can identify this document.
It appears to be a document from my records. It appears to be something that perhaps I created. Looking at it right now, it doesn't look familiar to me. I'm not disagreeing with it. I'm just saying I would need to just flip through it. I just don't happen to remember it right now.
It does have on 001, it looks like your contact information.
Mr. Sylvester, I agree. I just don't happen to remember creating this document. That's all I'm saying.
But you've seen it at about the time that it certainly was prepared in 2023, in which your name appears or your contact information appears below in the right-hand corner.
Yes, it does. I would just like to see a few more pages of it if I
You
could.
can
I'm
see
just
the
trying to
name.
refresh my memory
That's
with
what I want you
it.
to do. I want you to go through and Brendan, on her mark, if you would turn the page.
Okay, may we turn the page, please? Turn the page, please. Turn the page, please.
Accepting.
Turn the page, please. Turn the page, please. Turn the page, please. Is that it? Okay. Mr. Sylvester, I agree. It appears to be something that I created. It came out of my records. I see the stamp. I don't know that I actually created this document. I am sure I edited it. Otherwise, I would not have put my own name on the cover of it. I believe Mr. Clay Jensen created this in support of a client that he was pursuing at the time to do a renewable energy project on the property that's identified on 3818-0008. But I honestly, sitting here today, I don't remember why this was created, or it's simply not, I'll be honest, I don't know how to do some of what this document shows, like the brown header at the top of the pages that has the numbers on it. I don't know how to do that. Literally, I don't know how to create that document. And the table of contents page, similarly, it's far too, I did not create that document. And my secretary, whom I adore, she also does not know how to do that.
Let's assume it's Clay Jensen, as you speculated, not
Okay.
pejoratively, but was the intent of CSI to market a portion of Lincoln property for renewable energy?
CSI has tried to do that for a very long time.
And if we can just go I'm sorry, offer 3818, please.
No objection. Admitted.
Go back to, if we can, Brendan, 3813. Do you recall this document, Ms. Cargill?
Yes, I recall this document. Did you and I review this 2-3 days ago?
I believe that we did. I'm just asking you to orient yourself in time with respect to when that letter was issued.
March of 2023.
To whom was it sent?
It was sent to Mr. Sino Jr. by Mr. Clay Jensen.
And it relates to what we talked about, the potential of land in Lincoln County, the subject of renewable energy, right?
Yes, it does.
And there was, I think, a reference to estuary in that document. Do you recall having looked at that yesterday or the day before?
Yes, you're refreshing my memory. It accepted out estuary from any fee to be paid to Mr. Jensen.
And typically when, again, if only if you know, to the extent that you have a listing agreement or a brokerage agreement, if you've already had contact with a potential buyer or a lessor, you would sort of accept that out from any proposed compensation that's, for instance, Mr. Jensen would have received in connection with marketing, selling and or leasing that property. Do you understand that generally?
I understand the concept that you're describing, although I would not describe Clay as a broker or any of those sorts of terms, because he is, well, he may be, I don't know. That wasn't why we were engaging with him, because we did not believe he was a broker or that sort of category of person.
But whatever capacity he was, to the extent he was successful in doing that, selling or leasing for renewable energy, it appears that that document would have entitled him to some compensation. Would you agree with that, at least generally?
Yes, and I don't remember who was paying him or how it was. I don't remember any of that. I just remember, because you refreshed my memory, that we had accepted out estuary.
And I believe we looked at an amendment to the development agreement yesterday that was dated June 27th, 2024. And Brendan, if you bring up 3825, please. Just to orient you, go to the development agreement, please, the amended.
Yes, we discussed this yesterday or at some earlier day in my cross-examination.
Right, and you recall, generally speaking, that the purpose of that amendment to the development agreement was to carve out more land that might be available for renewable energy.
Any of the land in Lincoln County could be used, any or all of the land in Lincoln County could be used for renewable energy, subject to a reduction in the number of residential units that were otherwise allowed.
When was that development agreement approved? Can you tell from that document?
We'd need to look at the signature page. I see it was in 2024 because of the ordinance number, but May 6th, 2024 is the date the board signed it.
And just going back to that document we looked at before from Mr. Jensen, is it fair to say from having reviewed that document that CSI was already in at least some discussions with Estuary with regard to potentially buying or leasing a portion of Lincoln County for renewable energy?
I think we had entered into at least a letter of intent by 2023, Mr. Sylvester, but if you want me to get real specific, we'll need to just look at the document to reorient my head for the time frame for the first estuary NDA or letter of intent or whatever it would have been, but it would have been on the Lincoln County side.
By the way, can you still, under the terms of the amended development agreement, can you still have residential on the Lincoln County portion of the property that's not dedicated or used for renewable energy? Only if you know.
I don't believe it was excluded, let's put it that way. I believe it would still be an allowed use if if the property's not being used for solar.
And can we bring up States Exhibit 3869, please? I'm sorry. Yes, 3869. And this is one of the documents we looked at earlier in your examination. And I think you said this is that 2021 second amended complaint was superseded by the third amended complaint for damages.
Yes,
And this is I think you used the word operative complaint or something like that.
I think I probably said that word, yes. Third amended complaint
Mhm.
filed October 9th, 2023.
And this then would be after some initial discussions with Estuary, at least from a timeline perspective, as we've demonstrated. Would you agree with that, at least on the timeline perspective?
I believe I just said I don't recall the specific date of our first interaction with Estuary that was in terms of an agreement or letter of intent or any of those things. Mr. Sylvester, you could likewise show me that it was in 2020. You could likewise show me it was in 2024. And honestly, the years have morphed together a bit.
I appreciate that. But as it relates to the takings claim in the third amended complaint, if you can recall, and I'm happy to let you peruse that document, the taking claim, at least as asserted, is related only to the Clark County portion of the property. Do you understand that's the operative claim today?
Yes.
Can I have trials exhibit 3840, please? And you can enlarge that if you would, please, Brendan. And do you recall this document, Ms. Cargill?
I don't recall sending it. I see that I did send it. I don't know if this came out of my files or estuaries files. I can read the email and I see I sent Maddie Leonard an email September 10th, 2025.
Maybe just read the third full paragraph into the record, please.
The third paragraph?
Yes, ma'am.
I will say parenthetical and then I'll stop talking about it and parenthetical, that from our perspective, it's a lot different to have estuary tie up the majority of our land in Lincoln County versus just the northeast corner of the Lincoln County land. Especially as we still hope for development in Clark County if we can change the state's mind, parenthetical, as unlikely as that seems right now, and parenthetical. We may need utility easements, and from a developer's perspective, from the developer that is selling you the land, it doesn't feel good to say that you can tie up all of our land and we don't get a reasonability standard for easements that we may need in the future. We spent over 10 years getting that Lincoln County land, time, money, and a lot of work personally and through third parties to get the CSI Lincoln County land to a place where it can be developed.
So as of the date of September 10th, 2025, fair to say that CSI was still hopeful it could proceed to develop the master plan community?
No, I say as unlikely as that seems right now. And the purpose of this email, now that you've had me read it, it had to do with utility easements that Estuary was negotiating with Lincoln County Power District for utility lines and substations and where those substations would go on the Lincoln County side of the property. And depending on where those connections went, did the connection, which direction did it go? Whose land did it cross? And in some cases, they wanted the easement lines to cross directly across the Lincoln County land over land they were not optioning to purchase in a way that would make development of anything else on the Lincoln County side of the property then revolve around estuaries transmission lines.
Okay. I'm just looking at your words, even though it seemed unlikely, you were still at that point hopeful you could change the state of your mind. Would that be a fair characterization of your letter?
Objection. The question was asked and answered.
It was asked, it wasn't answered.
Oh,
I would stand by what I said, which is as unlikely as that seems right now.
I believe it was in yesterday. If not, I would offer state's proposed 3840.
No objection.
admitted.
Brady, can I have state's proposed 3826? Seems to be similar to the one we looked at from the DOT a little while ago. Just take a moment to review that document and tell me if you can recognize it or identify it.
Yes, this is in that same Nevada Department of Transportation project application that I described. And as I described, NDOT took several different runs at getting a grant, meaning they applied 2 or 3 different times for a grant to fund this program. And this letter is dated August of 2024. And it looks like they changed their form. The majority of this letter came from their information. For instance, if you look at the paragraph that runs from the bottom of the first page to the top of the second page, that is not my language. That's me just including the words that NDOT gave me, Nevada Department of Transportation gave me regarding parts of their project. And that's what this letter is. This letter is to one of the other individuals besides the head of Nevada Department of Transportation. And this is one of the other people that I referred to, the Honorable Pete Boutique, I'm not sure how to pronounce his last name.
Buttigieg,
How?
maybe. Buttigieg?
It could be Mr. Sylvester. I don't know. At the United States Department of Transportation. Again, this was a request by Nevada Department of Transportation for us to support the 2024-26 Wildlife Crossings Pilot Program.
And again, do you know why it is that CSI is cooperating with the Department of Transportation with respect to their request and then your response? As of August 20th, 2024.
Because we have always tried to cooperate with state agencies. We still to this day provide water for the Nevada Department of Wildlife for their various guzzlers and other wildlife assistance facilities. We have always, since the beginning of time, allowed Nevada Department of Transportation to park vehicles at Coyote Springs if they're doing projects in the valley, so they don't have to park them right along the highway where they might be vandalized or stolen. We've allowed them to get water for free from us, and we simply try to be good neighbors. And that would be the sole reason that we were assisting them. It had to do only with our assistance to them.
And can you describe and read into the record the second full paragraph where you're describing to the Honorable Pete Buttigieg the scope and nature of the project, if you will, the master plan community?
Yes, I think it's probably identical to the paragraph from the prior letter.
Mhm.
CSI owns the Coyote Springs Master Plan community in Southern Nevada. Parenthetical, the Coyote Springs MPC, and parenthetical. The Coyote Springs MPC spans 2 counties and encompasses more than 43,000 acres. Coyote Springs MPC is a fully approved and entitled master plan community with 40-year development agreements in 2 Nevada counties, Clark and Lincoln counties. Those development agreements allow CSI to develop 110,000 residential units, associated non-residential, commercial, recreation, community facilities and infrastructure, and industrial, and over 9,000 acres of renewable energy generation in Lincoln County, Nevada, and allows CSI to develop 49,600 residential units, associated non-residential, commercial, resort gaming, recreation, community facilities and infrastructure, and industrial in Clark County, Nevada.
That is an accurate description of the master plan community as of August 20th, 2024.
It is an accurate description of the development agreement in Lincoln County and the development agreement in Clark County.
I would offer state's proposed exhibit 3826.
No objection.
May I have state's proposed exhibit 3827? And can you describe, well, first, this is correspondence dated August 20th, 2024. The second page appears to have your signature as well.
Yes, it does.
And describe for the court for what purpose this letter is being written.
This is the companion letter to the letter that we just looked at to the U.S. Department of Transportation. This is the companion letter to the Nevada Department of Transportation. And as I described earlier, Nevada Department of Transportation gave me the names and the persons to whom to send these letters. And that is what we did.
Okay, and I'm not gonna make you read it, but
Thank you.
if you would like to compare the prior 2 letters, just from your review, reflect whether those 2 paragraphs are the same as it relates to the definition and scope of what's referred to as the Coyote Springs Master Plan Community. Would you like to see the other one at the same time?
That would be lovely if I could see just that second paragraph on the first page.
You want to highlight those 2, Brandon, so she can read them?
It would be easier for me if they weren't done that way, if I could just look at them side by side the way they were. Thank you. Yes, I believe they're, with one exception where in the first line I say S Nevada in the letter to the States Department of Transportation, and the letter to the Nevada Department of Transportation, I actually spell out Southern. I think that's the only difference between the two paragraphs.
If I can have you just turn to the last page at or the second page, 002. And if you would, read into the record the second to last full paragraph that begins CSI supports.
On which letter?
I'm sorry, the second letter, the letter to Tracy Larkin.
Okay. CSI supports the NDOT-CSWC project. To that end, and assuming development of Coyote Springs MPC is continuing and has commenced, CSI is willing to provide support of NDOT's project through in-kind funding by providing water to NDOT for dust control purposes as it constructs tortoise exclusion fence in the project area for the NDOT-CSWC area. Encouraging Lincoln County Authority on Tourism to include a free message on their quote display signboard end quote along US 93 in Lincoln County, Coyote Springs MPC, and by providing space on an existing info kiosk at Coyote Springs Golf Course's front area for NDOT to include public messaging about this important NDOT-CSWC project. The value of this in-kind contribution is in excess of $50,000.
From your review of that document, does that suggest, at least to the reader, that CSI is intending to move forward with the development of the Coyote Springs Master Plan community?
Objection, last foundation.
This is your letter.
That's about what it would tell the reader.
Objection mark.
I just said it was, the foundation went to, you asked about, would this convey to a reader?
Probably calls for speculation. Did you intend to convey to the reader that CSI intended to move forward with its master plan community?
No, that wasn't my intent there.
I think that will take us to the break, Your Honor.
Yes, today we'll reconvene at 1:30 instead of 1:15.
1:30. Okay.
Thank you. Before we do it, please submit proposed 3827, please.
No objections.
Admitted.
And thank you for the extra 15 minutes.
All right.
Alrighty, we'll be going to a lunch recess. What I'll do is I'll get the notes out for the update up to the lunch recess here, and we'll put that out. We'll be back. I'm going to clear the internet connection here because it seemed like I've been having some low latency and some issues with the connectivity, so we'll get a fresh connection going. And thank you once again for tuning in this morning. You've been watching W4Nevada Lives. We are on day 9, continuing coverage of the Coyote Springs LLC versus the state of Nevada. As far as I know, we are the only outlet that is covering this story. I appreciate each and every one of you for tuning in. So Carson, Churchill, Clark, Douglas, Esmeralda, Elko, Eureka, Lander, Lyon, Lincoln, Mineral, Nye, Pershing, Story, Washoe, White Pine counties, Humboldt. We love you. We're going to see you again. We'll be back here in just a little while. Thank you so much.
The camera's turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky, we're watching the records, we're asking them why. Oh, W4 Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town halls, unity in every Nevada town. If the shadows are growing and you need some sun, bring it to us. Now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com. You know where to go. Call or text that number. Let the power flow. 702